Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning to the attorneys and welcome to the Tennessee Court of Appeals. This morning, your case will be presented as if we were in court, except that you will not need to stand. I had to include that. I said that one day, and some of the lawyers wanted to stand, thought that they should stand, but you will not need to stand, but present your case as if you are in court. We need to know how many arguments are going to be presented this morning, how many on each side. On the side of the appellate, how many arguments will there be?
Your Honor, I'm Steve Riley and I represent the appellate. I'll be presenting the argument opening and rebuttal.
Okay, and what about the appellee?
Good morning, Judge McClarty. I'm Ron Hill. I will be presenting the argument on behalf of the appellees. Mr. Fansler and I are in this case together, but I believe he is yielding the time to our presentation.
And the next question we need to know is, these both cases involve very similar issues. Do you prefer that we keep these cases separate and argue the first case initially, the Ray Thompson case initially, and then the other case afterward? Or how were you planning on doing that? Or what is your preference, rather?
Your Honor, on behalf of the appellate, we have prepared to argue them together. They do involve the same issues, some different documents, different dockets, but the same legal issues and many of the same factual issues. So we would prefer and plan to argue them as one.
Okay, and for the appellee?
Yes, Judge McClarty, we agree. We had planned to argue these in unison.
Okay. Will you be requesting, since you're combining the cases and arguing them together, are you requesting an additional time for each case? Other than 15 minutes.
Your Honor, on behalf of the appellate, I believe we can present our argument within 15 minutes, depending on questions by the court.
Okay, and the appellee?
Your Honor, we had planned the same 15 minutes for the complete.
Okay, we will do that, but we will be mindful that you may, depending on the court's questioning, you may need some additional time. So I'll give you a little bit of leeway if that's what you need, since you're going to be doing it together. Okay.
Thank you, sir.
Now, your panel consists of Judge Davis, Judge Frison, and myself, Judge McClarty. Are the parties ready to present their case?
Appellate is prepared and ready to go forward, Your Honor.
Appellees are prepared and ready to go, Your Honor.
Madam Clerk, are there any preliminary matters that have surfaced that we need to consider first?
No, Your Honor.
In that case, I would ask you to call the first case.
In re Estate of B. Ray Thompson Jr. and in re Estate of Juanne Jennings Thompson.
Thank you. Appellant, you may proceed.
Thank you, Your Honor. And I appreciate your allowing us to do this by Zoom. This is my second argument by Zoom, I believe, and it appears to be efficient and appropriate, and so thank you for allowing us to do that. It is different arguing a case sitting down for me, but Your Honor, I represent the appellant and the proposed intervener in both of these cases. By this appeal, we seek orders allowing our client to intervene in both cases, and we seek an order unsealing all of the records, judicial records, in both of these in rem probate cases that have been sealed now, many of them for many years. Our efforts to unseal these records have been thwarted at every turn since early 2019. The probate court in Knox County, at the behest of the Appellees, had cloaked these judicial activities under seal, and these proceedings were in large part conducted in secrecy. After extensive motions, hearings, and actually 2 orders of this court, sua sponte, some of the judicial records have now been unsealed. The last unsealing of records occurred as a result of what we have defined in our brief as the 3rd sealing order, and that is the order of the Chancery Court that was entered on July 30th, 2020, with findings of fact and conclusions of law. Initially, that order itself was sealed, but was unsealed at the request of this court, and that order has given us additional documents, but the critical documents in terms of what the court did below are still under seal. The background of how we got here, may it please the court, I think is adequately detailed in our briefs. And unless there are questions about it, I would like to just turn directly to the documents that are still under seal and address them in particular about those. First,
excuse me, counsel, for interrupting. I just wanted to clarify. I have a copy of orders which were entered June 24th of 20, and you referenced a later order. But those orders, I believe, have attached an Exhibit 1 showing some records now unsealed and others sealed. Is that Exhibit 1 to the June 24th orders an accurate description of what still remains under seal, or is there a revised Exhibit 1?
Your Honor, I believe that that the Exhibit 1 you're referring to, I think it's at record 494 in the Juanne Jennings Thompson case I'm looking at, as far as we know, is an accurate record. And I say that because it is from that spreadsheet, I think, that exhibit that you're referring to, a number of documents were unsealed, records were unsealed, and then it references those that are still under seal. The footnote I would make with respect to that in your question is in the order, and particularly at page 7, paragraph 18, and that's at record 475 in the Juanne Thompson case. There is reference to an agreement that the court apparently had or has that settled the disputes among the trustees and executors as a result of the petition to remove them. And it also refers to a joint motion of the parties to dismiss that petition as a result of that settlement. Nowhere in the docket can I find that joint motion. Nowhere in the docket can I find that agreement. Perhaps it is part of the documents that are filed under seal, and therefore I haven't seen them, and it's just not identified in specifically, but it's referred to by the court. It was relied upon by the court in that on record 475, and there's a like cite to the record in the B. Ray Thompson case. And so we would like to see that agreement and see that joint motion because the court has obviously dealt with it in its and is aware of it as reflected in its order, but I can't find it on the docket. And so we would like that document unsealed. If it's not in the records that Your Honor, that the court has under seal, we would like for this court to order that it be produced by the trial court or wherever it is. But clearly the court has it and we haven't seen it. I hope that's responsive to your question.
Yes, sir. Thank you.
This court, sua sponte, issued an order on November 13th, 2019 that details the law that controls this matter. The so-called protective order, the first sealing order that it refers to, claims to have been issued pursuant to Rule 26, but that order, which remained under seal for a long time, does much more than what a Rule 26 order might do dealing with discovery. And in fact, that order goes so far as to close the doors of the courthouse, the probate court, with respect to all hearings and other matters relating to this matter. So there could be, there could have been activity that occurred in this case that we'll never know about because the orders were closed. It also sealed documents. It sealed judicial records. It sealed discovery that was filed, and it also related to unfiled discovery. It was the first.
I'm sorry to interrupt you. I'm going to move you forward just a little bit and kind of hone in on an issue that I'm curious about. Is it your position? Let's ignore the Rule 26 issue, and he did talk about compelling interest, and let's assume that's the correct standard. Is it your position that that protection of privacy interests, be it financial or for minors, can never be a compelling interest?
No, I think that it could be a compelling interest, and I think that it would have to be shown to the court to be a compelling interest. There would have to be some factual basis for it to be a compelling interest. A broad statement that the parties to a probate proceeding, their financial interests or have a privacy right that's a compelling interest is insufficient. However, to do so would to say essentially every probate case should be sealed, because in every case it deals with the disposition of assets of a deceased. So
perhaps if the chancellor in this case had made more detailed findings with respect to why there was a significant compelling interest because of financial or privacy concerns of minors, it would have been okay?
Perhaps, but given what we know about the matter, and now we have an extensive amount of material about what happened here, that is almost inconceivable to me. What it appears here was the basis of the court's determination. There was a lot of money at stake. Here now we know over $46 million that was to go to charity by Mr. Thompson's wishes, and that was changed somehow by this motion for instruction and approval that we haven't seen, Your Honor, the court has. So Judge Davis, I think that I would never say never to your question of whether financial interests could rise to a compelling interest, because I'm sure there could be a time that it occurred. But in this case, given these facts, that's almost inconceivable to me based on that.
Go ahead and continue. We're going to sort of give you a little leeway here.
All right, thank you, Ron. So I think the compelling interest test is the test. Is there a compelling interest? I think there's a second piece of that is, even if there was a compelling interest, is there a compelling interest in unsealing those? And then I think lastly, if the compelling interest to seal outweighs the compelling interest to unseal, there has to be something narrowly tailored here. And there is nothing there. There's never been anything in connection with this court's sealing records that's been narrowly tailored, and that continues today. What we have here is a motion for an approval, an instruction, and 8 exhibits that's sealed. I don't have it, you do. The trial court did, the appellees do, but it is apparent that that motion asked the court to take some action with respect to approving some kind of activity involving the disposition of these estates. And indeed, as a result of that motion, a final judgment was entered. I don't know what's in those documents. I've made inferences about it based upon the information that we have, but we don't have those. So what we do have, though, is a clear judicial record. We have a record that the court relied upon, records that the court relied upon in entering an order, taking action by the court. And under all the case law, it is almost inconceivable that that's not produced and made public. There is also a petition to set aside that was filed by Mrs. Thompson, counsel, and was not completed until after her death. That petition is now under seal. It was not under seal for many years and became under seal by what we call the third sealing order, the order of last summer. And in fact, it was filed in the Davidson County Court and in a case that's related to this, and it's filed in this court's record. And it's inexplicable to me how the appellees could seek to now uphold the sealing of that document. That's a document, though, that started some of this because it was the document in which Mrs. Thompson alleged that her husband had made fraudulent transfers of over $46 million to charity to avoid her elective share. And as a result, it was used, it appears, by the executors, trustees, and beneficiaries who sat on both sides because they were on both estates to modify Mr. Thompson's intent with the approval of the court so that more money went to Mrs. Thompson's estate and thus was transferred to her beneficiaries, who were not the charity, but were in fact the executors and trustees.
Mr. Riley, the litigation that is going on in Davidson County, is that still pending or has that been resolved?
It's been resolved. It was a case in which the trustee of the what we call the G10, the Grandchildren's Trust, sought to withdraw. And in connection with
no active litigation going on with respect to either of these 2 estates. Is that correct?
Not other than in the probate, not other than the cases themselves, correct?
Right.
Yeah. So in the Juanne Thompson case, or excuse me, in the B. Ray Thompson case, we have petition to set aside, a motion for approval instruction, the exhibits to that, and then the final judgment that was entered as a result of that. And then perhaps, and so that's what we know about that's under seal. And we say there's been no compelling interest shown with respect to those. With respect to the Juanne Thompson case, what happened there and what's under seal is as a result, apparently, of this determination that's under seal in the B. Ray Thompson case, in which funds were transferred into the Juanne Thompson case. The executors, trustees, and some of whom were beneficiaries had a dispute over those very issues. And the family executors and trustees who are beneficiaries to the Juanne estate and therefore apparently financially benefited from the activity the B. Ray Thompson case, sought to remove the one trustee who was a non-family member and not a beneficiary of Ms. Thompson's trust, excuse me. There's a removal petition in which they make allegations of breach of fiduciary duty against Mr. Huddleston is his name. There is his answer and counterclaim in which he makes allegations, breach of fiduciary duty with respect to each of the executors, family executors, trustees, and beneficiaries. There are statements about misrepresentations made to the charity that was to be the beneficiary of the Thompson estate. Of course, we haven't seen those. They're under seal. The court has them. As a result of that removal petition, apparently there was a settlement agreement. I haven't seen it. I can't find it on the docket. The court said there was a joint motion to dismiss the petition as a result of that settlement agreement. I can't find that. It's not on the docket. Perhaps it is in the sealed files that you have. As a result, though, those allegations were resolved. We haven't seen the allegations. We know they're about this very issue. What this case comes down to, and I know I'm gone over my time. I appreciate
All
the
right. Yeah, we'll
extension
give you
here.
a little bit of leeway. Go ahead.
Thank you, sir. What this the case really comes down to, and why, frankly, it is so important, is this goes to the public confidence in our judicial system, and that is a reason, as this court has noted in its orders and the law notes in many places, that there is this strong presumption of open records of our courts, because here the credibility of the courts, the credibility of the courts system, and public confidence in this is shaken. We have a charity at issue here. We have a gentleman who had a large amount of money, gave nearly $46 million to charity. The charity is a party to this case, but has not participated in the litigation. I don't know why. And as a result of the activities of the court, it appears that funds that were intended by the Mr. Thompson to go to a charity were instead diverted to his wife, who the court says in its order, the trial court, the probate court said, disagreed about how their estate should be handled, and then was distributed or available for distribution to the executors and beneficiaries, trustees. That's what appears to have happened. What we have here is a case that is even more than what you see in most of our cases dealing with court records, and even the Shane case, which is the Sixth Circuit case, which has really, I think, changed the way trial courts handle these matters in the federal system. What we have here is a case that really does raise at its core the integrity of the judicial system. And while there's been no showing of any compelling reason, interest, the compelling reason to disclose these is really quite overwhelming, I suggest. There's issues here they raise about minors. Well, I suggest that's a red herring. There are two beneficiaries in relative terms of very small amounts of money that are detailed in here. They go to a trust. There's a corporate trustee. That's what the Davidson County case was about. And even The mother of those two minors, who is an appellee, made no request that any of that information be redacted in any way, and there was no sought to tailor any of that information. The fundamental issue here is the court's taken action to benefit private individuals when we have a public charity involved that is contrary, appears to be quite contrary to the intent of Mr. Thompson. And all of that is cloaked in secrecy, which shakes the credibility and public confidence in our judicial system. And for those reasons, we ask that this court order the unsealing of all those records.
Thank you, sir. You have your rebuttal for the appellee.
May it please the court, I'm Ron Hill for the appellees Adela Thompson and Rebecca Thompson Palmer. This court should affirm the trial court for three reasons. One, the standard of review here is whether or not the trial court abused its discretion, and it did not. Secondly, even though the appellant was not allowed to intervene at the trial court level, that's really moot because this court took care of that when it remanded the matter back to the trial court to go through the more detailed analysis and document by document review. So that was taken care of in that remand and in that redoing of what is typically called the third sealing order. And so that's really moot. And then for the third reason, the appellant here has really shown no proper purpose for the records to be unsealed. They've made this speculative and vague claim that really nobody else is complaining of. The only one complaining here is the one grandchild of the 10 grandchildren of Mr. and Mrs. Thompson. No one else is complaining. The Attorney General is not complaining. The public is not complaining. The charity even here is not complaining. So for all three, yes.
Let me interrupt you. That's not really the issue, though. It is whether people are clamoring to get access, because we start with the very strong presumption that everything that's filed in the court is going to be open. And then it is up to the person seeking to close access to the records to show that there is a compelling interest. And typically, as you know, those are limited to things like trade secrets and the like. And so what in this case makes it so unique or so special that parts of it need to be sealed, other than the fact that we're dealing with a large estate?
Yes, Your Honor. Certainly, as we all know, there is certainly a fundamental concept that the courts are open. There's no question about that. And in the initial orders, and I think even the trial court acknowledged in its most recent order, the trial court acknowledged that initially there was a blanket order, could be called a blanket order, that protected and sealed all these documents. But when this court sent it back to the trial court to review everything, the trial court carefully went through each document and through the compelling reasons that the trial court found. And the trial court did find that there were compelling reasons, mainly privacy, but also the financial interest of the parties. And then the court also found that there were interests of minors involved, and there are. And the trial court did find that there were compelling interests to keep the documents sealed that the court determined should remain sealed. Now, I hope that answers the court's question there. Certainly, there's a disposition for the courts to be open, no question about that. None of the cases, of course, say that all records have to be open and that there's never any occasion or any reason for things to be sealed. And we submit that here the trial court went through it carefully, used its discretion, exercised its discretion to determine which documents should become unsealed and which ones should remain sealed. And I believe it was Judge Frierson that asked the question about the exhibit, and certainly the exhibit to the most recent sealing order, the one that was returned to this court after this court remanded it to the trial court for that analysis, that exhibit included with that third sealing order does set forth in detail which documents the trial court found should remain sealed and which could be unsealed. So the trial court, we say, remedied the blanket nature of the previous sealing orders that simply sealed everything. And the trial court took care of that. Now, appellants say that everything here has been conducted in secrecy. And what I would say to that in response is it's not that things have been conducted in secrecy, but they have been conducted in privacy. These are not public parties in this case. These are all private parties.
But Mr. Hill, my problem with that argument is that can be made with respect to any lawsuit that's ever filed. And when I was in the trial court, I received several motions for people to seal pleadings because they contained salacious arguments, salacious accusations that the defense argued weren't true. But that's the nature of a lawsuit. I mean, no one wants to be hailed into court and have allegations made against them, and everybody wants their business to be private. So where do you draw the line if privacy is your compelling reason? How come some people get the benefit of it and others don't?
Privacy is, I would say, is one of the compelling reasons. The other does have to do with the fact that there are minors involved, as the trial court found. And I would say also that at the foundation of this case, you've got trusts that were involved. And as the court knows, one of the foundational reasons that parties use trusts is because they are personal. They're private, and they are vehicles in estate planning that are used to maintain that level of privacy. So that's a difference. And I understand certainly some people wish that when they got into a lawsuit that nothing that was addressed would be made public, but we know that's not the case. But we say these cases are different. And again, the trial court found that. And it's the abuse of discretion standard that we think is so important. It's not whether or not a reviewing court might come to a different conclusion about particular documents like we had in this case. It's whether or not the trial court abused its discretion. And that, of course, as the court knows, is a very difficult burden for the appellants here to overcome, because the trial court, we say, properly exercised its discretion. Now, another point made by the appellants in the opening argument was that they called the sealing order 1 closed the door to the courthouse. And again, that's the order that you might call properly a blanket order, but that's been remedied completely by the fact that this court returned this matter to the trial court to address all the documents that had previously been sealed en masse by that blanket order. So that's been taken care of. Now, appellants point out that the NCF charity, the National Christian Foundation charity, is a party here, and it is, but it has not filed a brief. It has chosen not to do that. And I think that is significant because that, again, shows that they are not complaining. They're not complaining about what was done here. The only party complaining is the one grandchild, Nicole Thompson. And I think that's significant. We don't have the charity coming forward and complaining about the proceeds of the estates that went to the charity. The charity could have done that. By the same token, as has been pointed out, the Attorney General could have come forward and intervened in the case. That's not been done. I believe, Judge Davis, you asked the question about the Davidson County case. And as appellants conceded, that case has been resolved. It's been concluded. And there are no other cases pending except the completion of the administration of these estates. That's the only thing left remaining, is to complete the administration of these two estates, of Mr. Thompson and Mrs. Thompson. And we submit to the court that there's no reason for this case to go back to the trial court for any further determination, and no reason for these records to be unsealed, because there's nothing for this particular appellant, Nicole Thompson, to gain from this except really just an improper intrusion into something that she really has no interest in. It's significant to consider that Nicole Thompson did file earlier in the history of this case. She filed her own complaint, tantamount to a will contest. She then voluntarily dismissed it. So the only party complaining here, being Nicole Thompson, again, one of the 10 grandchildren, really has no interest at all in this, in the administration of these estates. She's a beneficiary of the G10 Grandchildren Trust, but she has no interest in the administration of these estates. She's not an heir at law. Her father is still alive, so she has no interest whatsoever in the administration of these estates. Now, the appellants also make much of the public confidence in our judicial system being affected by what's happened here. But everything that has happened here has been examined by the trial court. The settlement, the underlying settlement of the, what I call the petition for elective share, which was filed by Mrs. Thompson, that was all determined or reviewed and approved by the trial court. Everything that has been done in this case has been reviewed and approved by the trial court. There's no indication of anything that ought to shake anyone's confidence in the judicial system. It's all been approved by the trial court. The only thing that we've really got here is, again, I hate to keep repeating this, but the one party, the one grandchild, who really just for improper purposes of intrusion is seeking to get these records unsealed, that we say there is a compelling reason to maintain the seal on, as found by the trial court. So we believe, as I said, for the reasons I stated, that there was no abuse of discretion. The appellant was given a complete opportunity to argue why these records should be unsealed. That's been taken care of by this court, remanding it in effect back to the trial court for that analysis. And then thirdly, again, there is no proper purpose for this particular appellant to be seeking these records that we maintain should remain sealed. No proper purpose except just the improper purpose of intrusion. So we ask this court to affirm the trial court.
Thank you, Mr. Hill. There's nothing further then. See no questioning. Thank you very much, sir. And we'll hear your rebuttal. Mr. Riley, I think you're on mute.
Thank you so much. Appreciate it. I was trying to keep the court from hearing the dogs bark in the background. The fact that the court approved these activities is the very reason why it is so critical that the documents, that these judicial records be approved, unsealed. The fact is that Mr. Hill, on behalf of the Appellees, tries to flip the burden here. The burden upon them is to show a compelling reason why they should be sealed. They have shown none. Judge Davis asked Mr. Hill, and his answer was privacy. And as Judge Hill pointed out, everyone would like to have privacy, but when you have a lawsuit, privacy is lost. And here, these very appellees filed these documents in order to get the court to do something that benefited them. And they're the ones that put these records at issue. If they didn't want to have these trusts as a judicial record, they wouldn't have filed them. So there has been no showing of compelling interest. They spend a great deal of time, Mr. Hill must have said 3 or 4 times, that we only have one child with one purpose, one improper purpose. Well, first of all, I would refer the court to footnote 3 of our opening brief with respect to why the other family members withdrew from this case after it's outlined in that footnote. But there are many people that have interest in this, including the public. This is not the end of the road in this matter. Based upon the determination of what we see, there could be additional activities, actions that are brought. If there's been malfeasance in some way, that should be addressed. I suspect the Attorney General could well be interested if, in fact, the public charity here has, for some reason or another, been persuaded to give up access to funds for some reason. And when that's in the documents, I'm not going to speculate what's there because I haven't seen it. Would be unfair for me to do so. But this is not clearly the end of the matter. And even if it was, the public confidence in what what the probate court had done. This is an in rem proceeding that binds everyone. It's actually different than certain other kinds of cases. An in rem proceeding in which this court has taken these actions in secrecy, or whether you want to call it private or secrecy, it's not known to the public. People may not even know to complain because they don't know what in fact has happened here. And so this is not an improper intrusion by this grandchild who has enough information to know what her grandfather's intent was. This is actually an action that is designed to improve public access and confidence in our judicial system. There's been no showing of compelling interest, and there's been every showing of a compelling interest to show there's been no showing of some kind of improper purpose. The purpose here is for the public to know what happened in this case and why it happened, and if something results from that, then it will result from it. And that is what lies actually beneath the stability of our judicial system. And so for those reasons that we would ask this court to unseal these records, allow us to intervene at this stage right now. The trial court has found that we are not interveners. The appellees have conceded that their position to the trial court there was incorrect, but we are not yet a party of the case. The original sealing order that closed the courthouse doors is still in effect. Under that order, it's not been rescinded, that if there was an action in the trial court, it would be behind closed doors, and we would continue to be outside those doors as a result of not being intervened in the case. So for all those reasons, we ask for to be allowed to intervene for an unsealing of these matters. Thank you, Ron.
I want to thank the lawyers, both the lawyers, for your presentation, your argument before this court. Your case now has been submitted to this court, and you will receive our opinion and ruling within the due course of time. Thank you both, and the lawyers may be excused.
Thank you so much.
This
Thank you.
court is in recess until 11:30 a.m.